Yeah. So, very good evening, my dear friends. Welcome. Got a gap of 3 days in between, and then coming to close of our session. And then, friends, I have explained in detail the issues pertaining to majority rule and minority rights. And then, with that, I have explained the rule of phosphorus orbital, the exceptions to the principle. Number of cases I have discussed it, and I know you have noted down. They were all uploaded on YouTube also now, and then you have got that particular benefit now. Now, what is important is that the last part of our discussion in phosphorus orbital exceptions, I discussed that in the event of oppression and mismanagement is found as provided under the Companies Act 2013, this particular rule of majority would not apply, and the court, that is now the National Company Tribunal, will interfere and then pass appropriate orders. The history is this: earlier they were all embedded in section 397, 398 to 409 of Companies Act 2000, 1956. They were originated in the 1951 amendment, which were carried from the British law, and then subsequently they were put as 397 to 409 under the provisions of the Companies Act 1956, and where they have put three stages: oppression, mismanagement, and then public interest, where even the company could be wound up under just and equitable grounds, and the central government is empowered to appoint directors, and the company law board at that time, it was originally embedded with powers or were embedded with the high courts. They were shifted to company law board, subsequently CLB, and from CLB an appellate hierarchy to the high courts, and in the high court it is first is appeal, followed by the original side appeal, OSCA, that is before the division bench. That has been now dispensed with. All the matters have been mostly transferred to the National Company Law Tribunal, even under the 1956 Act. And then those provisions have been taken off and then put under section 3, 241 to 246 under the Companies Act 2013. More or less, the provisions are same, with, of course, more powers given to the National Company Law Tribunal. Now, what this particular subject means? This subject tells you that in the event there is any oppression or mismanagement of the affairs of the company, then the shareholders, if it is shareholding in capital, that would be 10%. If it is shareholders in number, that particular number is stipulated under the provisions of the Companies Act. I will tell you that particular aspect, and then they have to file appropriate application. In the event that particular percentage is not secured, also one shareholder can file and seek permission, and if the NCLT considers it fit, then the NCLT can proceed further. Even a class of shareholders, in fact, are permitted to file a petition in this regard. And then even if public interest is affected, also it can be found out. So, friends, a very elaborative provisions have been made under section 241, read with 242. The powers or interest to the National Company Law Tribunal under 242, and the consequence of modification of agreements has been stated under 243, a class action, 245, and the right to apply has been provided under 244. And then that aspect I will cover. And then further, the provisions also speak of the penal provisions. In fact, I will give a briefing. There is no need to go into minutest details as sections you can read, but I have to give you the peripheral area. And what is more important is what is the definition of oppression under the Indian law, English law, mismanagement under the English law, Indian law, and then the public interest. What is most important here is the public interest concept. Business community, how comes into public interest? In fact, same is the case with regard to today CSR, the corporate social responsibility. This is also embedded in the provisions of the Companies Act 2013. The reason being that corporates have been put on a particular responsibility, failing which it follows a liability. This is how now the law is molded ultimately, and it's an improvement over 1956 Companies Act. So, my dear friends, to begin with, I take you to section 241, where for prevention of oppression and mismanagement under chapter 16 of the Companies Act 2013, section 241 to 246 contain the necessary provisions. And then one by one we will see. First is under section 241, where an application to the NCLT for relief in case of oppression, etc., could be filed. And then who can file? Now, any member of a company, that means any shareholder of a company with a complaint can file an application, provided he finds that, rather he proves that the affairs of the company have been or being conducted in a manner prejudicial to public interest. This is the most important aspect. Or in a manner prejudicial or oppressive to him, or any other member or members, or in a manner prejudicial to the interest of the company. That's where the mismanagement comes. Or there is a material change. Material change means change of board of directors and then staff, and not being changed brought about by or in the interest of any creditors, including debenture holders or any class of shareholders of the company, has taken place. Material change means substantial change in the management of the company. And whether by an alteration in the board of directors of control of the company, the directors, the manager, or in the ownership of the company shares, it has prejudicially affected the minority shareholders. And it has no share capital in its membership, there is a change considerable. And the affairs of the company are conducted prejudicial to interest of members on a class. In that means one is oppression, another is mismanagement, the third one is public interest. These are all the three things. And then in this concept, if there is a material change in the management, substantial change in the board of directors, or the shareholders' rights, or the class of shareholders, and then shareholders majority fallen into minority because of the changes, then an application can be filed under 241 for rectification, and then subject to the right which is provided under section 244, that is who can apply. With that, the application can be filed. Then the central government, if it is of the opinion that the affairs of the company are being conducted in a manner prejudicial to public interest, it can, through ROC, it can also apply to the tribunal or the MCA, and then MCA directly can approach the NCLT for this kind of orders. Now, what are the powers of the tribunal under 242? On this application, the tribunal has got multifold powers, and then it can do and undo things. This is the most important provision under section 242 of the Companies Act 2013, where if on an application made, the company's tribunal comes to a conclusion that the affairs of the company have been or being conducted in a manner prejudicial or oppressive. That's what I have told you. To the member or members, prejudicial to public interest, and then in that circumstances, to wind up the company would unfairly prejudice such members, but otherwise the facts would ensure that it should be justified the winding up, and it is equitable, just and equitable that the company should be wound up. Then the tribunal, with a view to bring an end to the tyranny and then mismanagement, can bring an end to the particular stalemate and make appropriate orders. what could be the orders without prejudice to the generality of the powers, that is, the inherent powers of the NCLT as laid under the provisions of the Companies Act 2013. This particular NCLT now, in fact, can pass appropriate orders, may provide for reliefs. What are the various reliefs which are stated in that subsection 2? Briefly, I tell you, one is the regulation of conduct of affairs of the company in future, purchase of shares, and then restriction on the transfer or allotment, termination, setting aside or modification of any agreements, and then the removal of the managing director or managing personnel, and then appointment of such number of persons as directors, imposition of costs, and pass such and such orders which would be given. And then a certified copy of the order shall be filed by the company with the registrar after it is given within 30 days from the date of passing. So, friends, multidimensional powers have been vested under subsection 2 of section 242. And then the subsequent consequential effect has been given. And if a company contravenes any of the provisions of this subsection 5, which says that where the tribunal passes any order under subsection 1, makes any alteration, tribunal, to the memorandum or articles, then notwithstanding any other provision, the company shall not have power except to the extent, if any, permitted in the order, to make any such changes without the leave of the tribunal or alteration. And then if the company violates this particular provision, then the company will be punishable with fine which shall not be less than 1 lakh rupees, but which may extend to 25 lakhs. And every officer will be punishable who is in default with imprisonment for a term which may extend to 6 months, or a fine which shall not be less than 25,000 rupees, but which may extend to 1 lakh or before. So this is a very draconian law, and then the provisions are stringent. Provisions are made stringent so that there won't be violation. Then, if any consequence, in fact, termination of modification of agreements take place under this subsection 2 of 242, under 243, then no, in fact, claim will be made and it will stand terminated forever. So section 243 speaks of that. Now the most important point to be written in the examination point of view: who are the persons eligible to move the NCLT? 10% I have been telling in the beginning. I didn't disclose other facts. Now I will tell you. This is under section 244. Under 244, the right to file an application under 241 is stated who can file, who cannot file. Basically, in the case of a company having a share capital and not less than 100 members of the company, or not less than 1/10 of the total members, whichever is less, not less than 100 members of the company, or not less than 1/10 of the total number of its members, whichever is less, or any member or members holding not less than 1/10 of the issued share capital, subject to the condition that the applicant or applicants have fully paid the calls. If it is fully paid share capital, 10% of share capital. Number, if it is 100, if the total number is less than 100, 1/10 of the total members. I hope now you understand 3 phases. Anybody fulfilling this condition, in the case of company not having a share capital, if company is having a share capital, this is the principle. Persons together don't have 10%. Total number are 90. 1/10 of 90 can file. No problem. Or if company having share capital, number are more than 100. 100 have to file if it is numerical. If it is share capital wise, 1/10, 10% of the share capital holding, one person is holding, he can file. I hope now you understand. Now you come to the next aspect. In the case of a company not having share capital, not less than 1/5 of total number of its members, provided that the tribunal may, on an application made to it in this behalf, waive all the requirements or any of the, to enable even a single member to apply under section 241. So, where share or shares are held by 2 or more, they will be counted as 1. And where any member of the company are entitled to make an application under subsection 1, any one or more of them having obtained the consent in writing of the rest can file an application on behalf and for benefit of all of them. 10%, for example, one with consent of others can easily file this particular application. So, friends, now what you understand by this? Under 244, the eligibility criteria is stated. 241, who can the particular powers, I mean the subject with regard to oppression and mismanagement, public interest, and then substantial change brought illegally, which could be challengeable, has been stated. 242, the powers vested with the tribunal. 243, consequences of declaring a particular agreement were in fact illegal or set aside. Then under 244, the right to apply, even single person can apply subject to consent taken by the National Company Law Tribunal. This is the most important provision. Then friends, under section 245, a class action. In fact, any number of shareholders, depositors, see here, this is the most important thing. Need not be shareholder. A person can be a depositor or a depositors or any class of them or any shareholder, as the case may be, as are indicated in subsection 2. May, if they are of the opinion that the management or conduct of the affairs of the company are being conducted in a manner prejudicial to the interest of the company or its members or depositors, they can file an application and then seek appropriate remedies. Section 245 is important. Suppose I have kept about 50 lakhs deposits. I find company is not properly run. My deposits will be in trouble. Then I will challenge and then I can move an application under section 245. Under 244, under 241, in fact, persons eligible under 244 must apply. Under 241, an application can be filed, in fact, by under 245, where, in fact, they find their interest is prejudiced. So, prima facie, 241 application is by only members. Under 245, even depositors can file, or any, in fact, member or members, even a single member also can file, and they can seek restraint order against ultra-virus actions, declare a resolution of alteration of memorandum as illegal, restrain the company from acting on such resolution, and claim damages and take such and such measures which are in the best interest of the company. Only thing is that they have to prove that this particular company is acting prejudicial to their interest and to the interest of the company. And then the tribunal is given a direction under subsection 4 here that tribunal has to examine whether the members are acting in bona fide and then they are properly acting, they are properly taking care, and then it is not a vexatious litigation. Because one member also can do that. For that reason, he should not ultimately abuse the power vested. For that reason, this particular provision has been given. Now, friends, the last provision is under subsection 5, the tribunal's regard how it has to handle also has been given. So, you have to read thoroughly section 245 and know the other provisions as thereon. Lastly, section 246, where the application of certain provisions to proceedings under section 241. The provisions under 337 to 341 are applicable with regard to mutatis mutandis under 241 to 245. What are the provisions of 337 to 341? 337 is penalty for fraud by officers, I already explained. 338, liability where proper accounts are not kept. Liability for fraudulent conduct of business under 339. And 340, power of tribunal to assess damages against delinquent directors. And 341, liability under section 339 and 340 to extend to partners or directors of firms in firms or companies. Directors in firms or companies. So, sections 337 to 341, where general provisions have been given against directors for committing fraud, are equally applicable with regard to prevention of oppression and mismanagement under the Companies Act, under the provisions 241 to 246 also. So sections 241 to 246 must be read with the penal provisions, that is the consequential effect of violation with regard to the directors committing fraud under section 337 to 341. 337 to 341 deal with the directors who have committed fraud and who did not maintain accounts, and then power of tribunal to assess the damages, etc. And the liability has to be extended to partners also, or directors in firms or companies. So, friends, with this particular background, the sections 241 to 246 contain about the provisions on prevention of oppression and mismanagement, and then the powers of tribunal are concerned under 240, in fact 242, where there is a particular violation or modification, the power is subsection 8 of subsection 8 of section 242. And then further, the provisions under 337 to 341, in fact, are equally applicable, wherein there is a fraud or such kind of thing. I request some of the students to please mute your mics, it is getting disturbance. So, friends, sections 337 to 341 are very important provisions which equally apply to 241 to 246. 246 makes a reference to sections 337 to 341. So this is the most important aspect. That way, 241 to 246 read with provision under 246, 337 to 341 also must be studied. Then your study will be complete. So, my dear friends, with this background, what you understand is, in the event there is any oppression or mismanagement or any kind of action against public interest, then the appropriate action can be taken by a member under 241. And then you have to understand, followed by the provision under section 242, the powers are vested with the tribunal. 243, the consequences. 244, the right to apply, so far shareholders are concerned. 245, class action along with depositors, even a single person can take an action. And 246, the application of the provisions with regard to sections 337 to 341. So with this background, I have concluded the discussion on substantive law. Now, what do you mean by oppression? What do you mean by mismanagement? What do you mean by public interest? What are the interpretations given by the Supreme Court in this regard, and how that interpretation has to be taken into account? These are all the factors I am going to discuss in length in tomorrow's session. That is part 2. With this, our entire program will be concluded with regard to oppression and mismanagement, prevention of oppression and mismanagement under sections 241 to 246. Friends, we will further discuss